Good afternoon, everybody. My name is Tara Lyons, and today I am joined by Samara Brackley, and we're going to be taking you through the new law in respect of no-fault divorce. If I could just mention that we have a chat box available for any questions. So if you could pop them in the chat box, and if we've got time, we will try and answer as many as possible. And also, you may be delighted to know that we will be sending out a copy of the slides for your information, and also the recording. So if you've missed any bits, please don't worry, you'll have that information available. So what will this session cover? We're going to have a look at the background very quickly to the introduction of the no-fault divorce law. We're going to have a closer look at the legal framework. One of the key points we're going to look at is the timetable for implementation. And then we're going to look at the principal changes, not just around the substantive law, but also the divorce process itself. And in particular, service and terminology and the application process itself. Samara is also going to be dealing with the issue of costs, which are vexing a number of people already. We all know that the current system involves an assignment of blame, and that is because a party has to demonstrate that the marriage is irretrievably broken down by establishing one of 5 statutory facts, including adultery behaviour, desertion, or the relevant period of separation, 2 years with consent or 5 years without consent. The court has a duty to inquire into the facts relied upon, and as we know, divorces can be defended. So as the slide shows, it is very much a blame culture for Eddie and the Dragon. Now, things came to a head in the case of Owens and Owens, which was a Supreme Court case decided in 2018. And I'll just refresh your memories on that, because this was a case in which the wife had petitioned for divorce in May 2015 on the basis of her husband's reasonable behaviour. And the statement of case contained pretty common themes, I would say. Mrs. Owens alleged that Mr. Owens had prioritised his work over their life at home. His treatment of her had lacked love and affection. He'd been moody and argumentative, and he disparaged her in front of others. And as a result, she felt unhappy, unappreciated, upset and embarrassed. Mr. Owens, being the man that he was, defended the divorce, arguing that actually his behaviour in the context of the marriage had not been unreasonable at all. During the proceedings, Mrs. Owens was given permission to amend her petition, and she did so by adding 27 particulars of Mr. Owens being moody and argumentative. Unfortunately, that wasn't sufficient, because at first instance, His Honour Judge Tolson QC, having heard evidence over half the day from the two of them, found that actually the behaviour complained of by Mrs. Owens was that which could reasonably have been expected to have been found to have occurred in a marriage. Mrs. Owens, unsurprisingly, appealed, and the Court of Appeal, I'm afraid, followed a similar vein, being satisfied that the judge at first instance had applied the correct test. That was the objective test of whether or not such behaviour was reasonable. Mrs. Owens appealed to the Supreme Court. As you probably are aware, resolution intervened, and she argued that Section 1(2)(b) should be interpreted not so that the court was looking at the behaviour, but so that the focus was on the effect of such behaviour, so rather a subjective element. And Lord Wilson and Lady Hale recognised that the decision at first instance was troubling, but unfortunately was right on the law. So poor Mrs. Owens had to wait until February 2020 to apply again under the grounds of 2 years separation. This couple certainly wouldn't have been able to achieve their divorce under the previous law. So what we see is reform, and what we get is the Divorce Dissolution and Separation Act 2020. That received Royal Assent on the 25th of June 2020, and it's going to come into effect on the 6th of April 2022. And it will allow couples to divorce for the first time without assigning blame, which it's hoped will reduce conflict within the legal process, which of course can be damaging not just for the parties, but more importantly, their children. It will promote individual autonomy and will hopefully reduce the length, cost and hardship of divorce. Although unfortunately, Samara and I, along with several other legal commentators, have identified some new battlegrounds for the divorce, so which we'll come on to in a moment. So what does it look like? The DDSA 2020 is an act that consists of 9 sections and a schedule. Unfortunately, it's an amendment act, so all it does is rather in a rather difficult manner to follow, is it says, for instance, section 2 is omitted, section 3 add the words XXX, and so it is very difficult to follow. We haven't found a sort of amended version online, but I do know that Michael Horton QC had prepared his own amendments so that they could be seen, but hopefully that will all come to pass, and we'll see the amendments on the 6th of April. In addition to the Act itself, we've also got 3 statutory instruments. The first is giving effect to the amendments to the family procedure rules. The second deals with fees, and the third deals with the actual implementation of the Act, so making sure it comes into force on the 6th of April. So, as I alluded to, the family procedure rules, part 6 and 7, have been amended. Part 6, which deals with service, has again been amended via amendments. Part 7 has just been wholly replaced, and Resolution have very helpfully produced those new parts on their website. We've included the PDF links here, so you'll get that when the slides are sent out. And the practice directions have also been updated in a similar vein. As I'm sure most of you will be aware, on the 25th of February 2022, HM Courts published an information pack together with a draft court forms and a practice direction update. And we got some more samples on the 9th of March 2022. The information pack is definitely worth the read, but I don't mean any disrespect when I say it doesn't give you all the information. I think it's really, really important to go and have a read of the new part 6, part 7 in their new form. And I think actually you will find that to be the most important updating information. The information pack gives a bit more guidance about the process for sole applicants and joint applicants, but definitely we would commend the base material. We've also given the reference for the information pack itself, which is found in the second bullet point. So under the DDSA 2020, instead of having to provide evidence of the separation facts or particulars, what's now required is that the applicant or applicants, if it's a joint application, provide a statement of irretrievable breakdown. And that statement will be conclusive insofar as the court will not look beyond it or behind it to consider whether the statement has been complied with. So we've got no requirement for evidence, we've got no requirements to raise allegations of adultery, desertion or bad behaviour. Some other fundamental changes. First of all, not just a sole applicant can make the application, but as is said, joint applications can be made, and I'm going to discuss a little bit more about that in due course. The other key change is that there is no longer the ability to defend or dispute the petition unless in very defined circumstances, which Samara is going to touch on. There is the introduction of a minimal overall timetable of 26 weeks. Now that is broken down as 20 weeks from the application to the conditional order, which was the decree nisi, and a further 6 weeks to the final order. That timetable cannot be extended by the court. In certain circumstances, you can apply to reduce it. And the aim of that is twofold. First of all, it's to give a period of reflection to make sure that everyone is sure they want to be getting divorced. So you have this 6-month period in total. And secondly, the aim, I think, is to make sure the finances are sorted out. We also see an update to the language, and forgive me if I slip between the two, but I'm going to just run through those changes. And as I've said, there have been some procedural changes. The principal change in respect of service is this, and Samara is going to look in more detail. The default is there will be service by the court instead of the applicant. The second big change is there will be email service as the default. So that's something that we're going to have a further look at as well. And just some particular points that are worth mentioning. Previously under section 5, the grave hardship bar applied. So if someone was able to evidence grave hardship, they could use that as a bar to the divorce. Now that no longer operates, that's been swept away. Section 10.2 is perhaps more important, and we've actually already been asked about this already. So previously, if the respondent wished to delay the granting of what used to be the decree absolute will be the final order, they could only make an application under section 10.2 if it was on the basis that their case had involved separation. That's obviously no longer the case because we don't have the different grounds. So every respondent can make an application under section 10.2 to delay the final order. And that application, and I'll come back to the last point on the previous slide in a moment, that application will mean that there is no final order unless the applicant can establish that they should not be required to make any financial provision, or that the financial provision made by the applicant is reasonable and fair and the best that can be made in the circumstances, or if the party undertakes to make provision. So there is a protection under a section 10.2 application, which we think will have to be made by a D11 application. The other point that I just made on the last bullet point of the slide is that you will still have to wait a year after marriage until you can apply for divorce. So you've still got the 12-month restriction. I should just say that for a conditional order, which we'll have to look at, there needs to be a separate application for the conditional order confirming that you want the divorce to go through, whether it's an applicant or joint applicants, and also there'll have to be a notice for the final order. So timings. Now, I guess now, given we are just a couple of days before the 31st of March. This isn't going to be that relevant, but I hope this is going to be helpful. The new law doesn't come into effect until the 6th of April 2022. Proceedings issued before the 5th of April 2022 will continue under the existing law. However, there's going to be a lacuna, I'm afraid, in which applications cannot be made because all paper and digital applications have got to be made by 4 p.m. on the 31st of March 2022. Beware, because of course you might send the application off, but it's not going to necessarily get issued immediately. So as we're on the 29th today, it's probably going to mean that you are going to have to wait until the new system comes in. However, we have got, again, one bit of protection, particularly for those cases in which there are jurisdiction races and issues of urgencies. Urgent applications can be made between the 31st of March 2022 and 6th of April 2022, but they're going to have to be conducted on paper, and they're going to have to involve you actually going to the court desk or emailing this particular email address that we've set out, and that's got to be done by 4 p.m. on the 5th of April 2022. Now, obviously, the problem with issuing an application now and it not being issued in time is going to mean that that application isn't issued. You've wasted the cost, and you're going to have to make a new application under the new system, which is going to involve potentially more cost and delay. So if you can wait until the new system, we say do. Having a look at the terminology, we're getting rid of the archaic terms. So there's no longer a petition, we're dealing with an application. There is no longer a petitioner, we've got the applicant. And in the case of joint applications, we've got applicant 1 and applicant 2. We've got conditional orders instead of decree nisi, final orders instead of decree absolute, and disputed proceedings instead of defended proceedings. The application process itself, a couple of things to note. It's going to be the same questions, whether it's a digital application or a paper application. It is going to be mandatory for legal representatives to use the digital service. However, there's one exception to this. If it's the same solicitor acting for both parties, then a paper application has to be made. That paper application is still going to be scanned into the electronic system. So be aware that any paper applications have to be uploaded, scanned and uploaded. You'll be able to use your same credentials. They will work. What you will have to look out for is the drop-down menu. Instead of just selecting divorce case, which was for existing law, you have to select new divorce case for new cases. So what about the timings of the application process itself? Well, day 1, you file the application. Day 28, the court, or if the applicant has applied, will serve the application on the respondent or both parties if it's a joint application. 14 days thereafter, the acknowledgement of service must be filed, including, we think, by joint applicants, which doesn't make sense because they are both applicants. 35 days from the date of service, if the respondent intends on disputing the proceedings, they must file an answer. 20 weeks from the date of issue of the application, parties can apply for a conditional order to allow for a period of reflection. Now, the application is the same whether it is for sole or joint applicants, and that's the form D84. We're going to be talking about the requirement for the 28 days of service and how that fits in with 28 days for service on the respondent and how that fits in with the 20 weeks because there is no sanction if an application is not served within the 28 days. So we're going to be looking at that part of it in a bit more detail. And then 6 weeks after the conditional order, both parties or one party can apply for a final order. The sole applicant or applicant one files notice for conditional order to be made final using form D36. However, if a joint application then turns to a sole application, you use a different form, form D36A. So who can issue? Well, the parties, as we've said, can make a sole application or for the first time issue a joint application. The expectation is that parties will make joint applications. Now, we have guidance in the information pack that one solicitor can act for both parties if they wish to on a joint application. Remember, that's got to be by paper. But as I'm going to explore actually when we deal with the question and answer session, because someone's asked us specifically, the occasions on which one solicitor will act for both parties, we think are going to be very few and far between, because they're going to be riddled with conflict issues if there are any issues about the finances and or the children. And so what we think the expectation is, or probably that the solution is that it's a matter of guiding your client to go and do a joint application with the respondent, if that's appropriate, by themselves, and for them to do it without solicitor involvement. So sole applications, the person is known as the applicant. Crucially, a sole applicant cannot convert the application to a joint application. So the decision about whether it's a sole or joint application has to be made at the outset. It can be made online or using D8, and we've got the new rules of service. Joint applications, we've got applicant one, applicant two. The application can be digital or paper. Where one or both applicants are represented by a solicitor, it's got to be digital, unless it's the same solicitor. Don't ask us why they must proceed by paper. What Samara is going to be talking about is costs generally, but what is clear is that even on a joint application, you can't formally share the costs. It has to be a matter of the applicant one actually paying, and applicant one and applicant two can decide between them how they want to divvy it up. So probably they want to try and agree that before applicant one pays the money. Applicant one and applicant two do not have to be in the same room. What actually happens is applicant one fills in the form, it's sent to applicant two to check and confirm, and then it's sent back before it's issued. And as I've already said, the application can be converted from joint to a sole application. And now I'm going to leave you with Samara. I'm aware that the chat box has been filling up with questions, but if you don't mind, we'll probably deal with them at the end, as many as we can get through. And if not, we can always try and deal with it by email. Thanks, Samara.
Thank you, Tara. So I just wanted to add a note about the joint applications, only because it was relatively easy for me to look this up, about whether you can, as joint applicants, apply for a conditional order to be made final. Yes, you can. I don't know who would have said otherwise, because I'm looking at the draft D36A that is on, and D36 that are on the resolution website. It's section 3, very clearly it says this is a joint application and we both apply for the conditional order made in our favour, and then you fill out the date, to be made final. So you can do that, and I've literally just checked that as it came up in the chat box, because I thought, gosh, I don't want to be giving you information that I can't verify myself right now. On the disputed point, again, just to very quickly deal with this issue that's come up in the chat box, the no fault issue, it's literally a tick box. On the new D8, it is quite literally a tick box that says, I confirm as a sole applicant that the marriage is broken down, or as joint applicants, I also confirm as applicant 2 that the marriage is broken down. You don't even provide a statement. There's no box for you to type anything. So nobody can possibly try and attribute blame. They have completely taken it away from us. It is, as I say, a tick box on the D8. So in relation to disputes, if you can't dispute blame, what can you dispute? So sole applications can only be disputed on the basis of jurisdiction. We're all familiar with that. Those issues haven't changed. The validity of the marriage or the civil partnership. So that is whether, for example, if you're dealing with a quasi-marriage that's perhaps taken place abroad somewhere, a non-proceedings marriage, and you're looking at it thinking, is that actually a valid marriage? You can dispute it by saying, I'm not entirely sure that we were married, or if your client says, no, we weren't married. The validity, the marriage or the civil partnership has already been legally ended. So I've put an example there that I'm sure people may have seen before. For example, if you're for a respondent, they say, hold on a minute, we've actually already had a talaq in Lebanon, or somewhere like that, where they recognise Sharia divorces. I have also assumed that capacity will also be an issue that you can dispute on the basis of. I don't see why you wouldn't be able to do that. Just a note on disputing the validity of the marriage. So this is an amendment to Practice Direction 7A. Both parties have now got a duty to provide the court with information about existing or concluded proceedings in respect of the marriage or the civil partnership, which might affect its validity or subsistence. So if it appears to the court, and they get this information, that there are proceedings outside of England and Wales that are capable of affecting the validity of the marriage, the court must, and it's a must, that's the wording of the practice direction, consider if it's necessary to give directions for a stay. And on the next slide, I have put in a screenshot of what's on the application. And I'm just going to pause there for a minute. No, it's all right. So on the, this is actually on the D8. So applicants are required to, when they're filling out the D8, say whether there are existing or previous court proceedings. They may say, well, actually, we had this jurisdiction dispute in France already, and so it's concluded and I'm applying for it here. But otherwise, I'm not entirely sure why you would be using that box. So on to service, and as Tara's already said, there are big changes here. And the biggest one is that the general rule is going to be that the court will send the application to the respondent. I'm just dealing with sole applications at the moment. So the court will send the application to the respondent, but the applicant can request to do it if they so wish. However, that general rule, so the general rule regarding the court sending it, that doesn't apply if the parties are protected parties, so if there are capacity issues, or if a party is out of the jurisdiction. Service out of the jurisdiction has to be done by you, the applicant, or the solicitor for the applicant. We've now got this other change that the applicant may not serve the respondent personally. And what that means is that you can't have an aggrieved husband go and knock on the door of their aggrieved ex-wife and physically hand them the documents. Tara and I are assuming that is to protect parties when there are allegations of domestic abuse. But anyway, personal service, just instruct a process server. But most of the time, as I say, the norm is going to be that the court is going to be serving and the court's going to be serving via email. If the applicant does wish to serve, what is good service, therefore? I have literally lifted this screenshot from the resolution amendments to the practice directions and the rules. So I really would, as Tara said, commend you to go and look at that material. It's really useful. I've put that in so you can see that first class post means what we all know it to mean. Personal service is leaving it with the person to be served, other than, and crucially, the applicant personally leaving it there. They can't do that. And then we've got email service under Rule 6.7a, and that is sending the application via email and sending the notice required, that's on the next slide, by posting it, leaving it, or delivering it by collection by the relevant service provider. Sorry, it's not the next slide. The next slide is dealing with the extension of time for service. So as Tara has set out within the timeline, the general rule is that an application, the service has to be effective within 28 days. Now, if you, for some reason, are not able to effect service within that 28-day period, then you can apply for an extension of that time to serve. Now, that application for an extension should, in normal circumstances, be made within that 28-day period. And this is this rule 6.6b2a, unless the party's got a good reason, in which case the application for an extension of service may be made after the 28-day period has expired. And what that means effectively is, as Tara said, there doesn't appear to be any sanction for not serving within the 28 days, because it appears that you can just make an application for service after the 28 days has expired if you've got a good reason as to why you haven't been able to effect service or apply for your extension to effect service within the 28 days. It's not clear what a good reason is yet. I'm sure there'll be some test cases about that when people start arguing about service, because Tara and I anticipate this is going to be an additional battleground. When somebody wants to dispute a divorce, they're going to start disputing that service has been effective. But in any event, when you're looking at this application to extend time for service, you've got there what the court will consider under rule 6.6b4. And that is whether the court itself has failed to serve the application. I think we are expecting to see some of those applications because of the backlogs that we're all familiar with. I can't necessarily see why the administrative structure of the court is going to change with the advent of these new service rules. So I think we all need to be prepared to make sure that the court is actually serving within the 28 days. Whether the applicant has taken reasonable steps to comply with the 28-day period as required, and whether the applicant has acted promptly. And that's going to be a separate application. And then we've got service via email. So this is also new. The email that is used by the applicant to serve on the respondent must be the respondent's usual email address, and that means a personal email as opposed to a business email. Now, usual email address is defined in paragraph 4A of the new practice direction 6A, and I'm just going to read out the precise wording so that we all understand what is meant by usual email address. And that is the email address generally considered to be the email address actively used by the respondent for personal emails. And the reason that is important is because we could see an applicant who is desperately wanting to get their divorce through just create a random email address for the respondent, say that there's been good service because there hasn't been a bounce back on the email. They don't need to worry about the postal notification, as I'll come on to on the next bullet point, and just basically get this divorce through on the basis of not using a usual email address. So it's been very clearly defined in terms of being a usual email address for personal issues. You shouldn't send it to a business address. There's nothing that says you must not, but it is a should not. I, for what it's worth, would have thought that using a business email would make the applications less subject to fraud, or sending to an email address that can't be verified if it's a company email address or a work email address. But I guess they're trying to protect people from receiving surprise divorce petitions via email at work.
So Samara and I had discussed that actually in a situation where you might have a respondent who is wanting to evade service, that there would be nothing wrong with, in addition to the postal notification, actually sending an email to the business email address to say, look, we've served you at that, at your usual email address, and highlight the point. Or alternatively, if there are issues, of course, you can apply for an alternative method of service.
In relation to email service, as well as sending an email with the service, that having been effective, the respondent must also be sent a postal notification via first-class post. So if you're leaving service up to the court will send the postal notification. If you want to do the service as the applicant, you've also got to send a postal notice. I'm afraid I don't know what the wording of the postal notification should be, because we couldn't find a template for that online anywhere, but you've got to do it. That being said, good service of the postal notification does not mean that you can dispense with effective email service. And likewise, a lack of receipt by the respondent of the postal notification does not mean the email service has been ineffective. From what we can work out, it's effectively just making sure via another avenue that the respondent knows that there is perhaps a petition, sorry, it's not a petition anymore, the application is waiting for them in their inbox because it might have gone to their junk or something like that. So service, as I say, will usually be by the court unless you as the applicant nominate otherwise. The applicant has still got to provide the respondent's usual email address as we defined earlier and their last known or usual email address. If an email is not provided or the applicant for some reason doesn't seek for it to be via email service, which you've got to nominate the court if that's the case, then the court will serve the respondent via first class post. And this bit is crucial, and this bit is in the information pack, and that's where we found it. If an applicant does not have a postal address for the respondent, so you've only got an email address, the applicant must apply for alternative service. And from what Tara and I can work out, that is a separate application, which is rather burdensome, but that is what the information pack says, that if you only have an email address, you must apply for alternative service, presumably to dispense with the requirement for the postal notification.
Yeah, you've got to apply for alternative service by email only by a D11.
Yeah, and that, as I say, we presume it's to dispense with the requirement for the postal notification, but if you've only got an email address, you'll have to make an application for alternative service. What happens if the court doesn't achieve service? I hear some of you asking. The court will notify the applicant of failure to serve the respondent, and I've put the rules in there for postal and email service, at which point the applicant may say to the court, can you actually serve the respondent at an alternative address? Once that second attempt has been made, the court won't make another, and you will have to make an application for alternative service. So you've got chance number one on your D8 to put in the correct contact details or what you believe to be the correct contact details. The court comes back to you and says, sorry, Mr. or Mrs. So-and-so, we haven't been able to effect service at that email address or at that postal address. Are you able to please provide us with another contact, some more contact details? You then go back and say, yes, I've got these, but that is your second and final opportunity. If you don't manage to serve after that second attempt at providing the up-to-date contact details, then the court won't make another attempt and you'll have to make an application for alternative service. I should add that obviously all of this, the clock on the 28 days is still running. So if it looks as if during this period that you're going back and forth with the court, you're going to need to apply for an extension of time for service, just to point that out. Service outside of the jurisdiction remains unchanged, so the court won't do it. You've got to do it. It must be done within the 28 days. Somebody asked that in the chat box earlier, so I hope that answers your question on that. Service is still 28 days, whether it's inside the jurisdiction or outside the jurisdiction. And there is a mirror provision for the extension of time, for the extension of that 28 days under Rule 6.41b. Alternative service, the application for that is under 6.19. Deemed service also remains unchanged. So next, some of these points to consider that Tara and I were musing on when we were putting this together in terms of, is this service issue going to become a battleground if somebody actually wants to dispute the divorce? Are they going to try and say, well, you didn't serve me properly, so therefore you've got to go back to square one and make a new application? Quite possibly. If an application for an extension is refused, then the divorce cannot proceed. And that's something to bear in mind. You've got to reissue, you've got to pay the divorce application fee all over again. And also, it doesn't seem to us that there are any express sanctions within the rules for failing to serve in time. Yeah. So if the respondent doesn't take issue with the fact that they haven't been served, then the application just proceeds. And you could very well end up with a circumstance where there has been proper service, and you get to week 19 before the conditional order is due to be applied for. And then only at that point does the respondent realise that actually they have been properly served and they need to dispute it because there's proceedings going on in France or the like.
Yeah, that's exactly the point, Samara, because where we think the service rules are really going to come to the fore is that in those cases where there are jurisdictional races. So if the respondent really wants to be difficult and then issue somewhere else, what it could do is wait, meanwhile issue an application in a different jurisdiction, and then contest the fact that they didn't receive the full 28 days service. If it is contested, the likelihood is that because it breaches the rules and without an application to extend having been made, that application would be dismissed, and the applicant would have to start again and lose that jurisdictional advantage. So whilst we see that actually there are no longer going to be really defended divorces, what we expect to see is these sorts of rules being used as a battleground to gain a tactical advantage.
I'm just going to mention it now because someone's put it in the chat box and it seems like an appropriate time to mention it. But the court, if you're leaving service to the court will get a notification that service has been effective. So if you need to apply for deemed service under Rule 6.16, you just go to the court and say, can I please have the notification from you that email service upon the respondent was effective, and they will give it to you. In terms of deleting emails, etc., we completely understand that there's room for manipulation here. And so what we have been saying when we've been discussing it with other people is maybe turn on read receipts on emails if you can do that, or delivery receipts, so that you have got proof. Or tactically, maybe send some emails to the respondent beforehand saying, hello, we are acting for the applicant here, or, you know, Mrs. or Mr. So-and-so has instructed us to deal with their divorce, and get some emails from them in terms of the service email that you're intending to use for the application, so that if you need to apply for deemed service, you can say, well, hold on a minute, they had already responded to a couple of emails to us last week when we said that we were instructed. They now appear to be evading service. We don't know why that is, but we can prove that this is their usual email address. That is what we have been discussing in terms of trying to get around that. So the next issue to discuss is costs. And until yesterday, there was no guidance on this at all, which was not particularly helpful, I have to say. And in terms of who is going to be bearing the cost of the applications, there still does not appear to be a default position, I'm afraid to tell you. I don't know whether any of you will have read the updated guidance when it came out yesterday, but effectively, because there is no scope to consider the conduct of the parties in terms of fault, the scope of success will be limited. So what the President has very clearly said yesterday in the guidance is that in standard cases, including in joint applications, costs orders will be inappropriate. The expectation for joint applicants is that they sort it out between themselves. And Tara and I have taken this to mean that the default will be no order for costs, which means that the applicant or applicant one should be prepared to pay the costs in the first instance. Again, I very much anticipate this is going to become another battleground, that people will say, I don't want to pay it because I didn't do anything wrong. Even though they haven't got an opportunity to say who did something wrong, they will still, in their heart of hearts, believe that they should not be paying the fee and the costs associated with getting divorce. That being said, it may also appear more in financial remedies. We may be now seeing on our ES2s the divorce costs being something that is going to be argued about in financial remedies. That's what I predict in any event. In relation to the procedure for costs applications, they're dealt with under paragraph 12 of the new Practice Direction 7A. For standard cases, if you do want to make a costs application, although the warning has very clearly been given by the President that these would be considered inappropriate, you need to make it again by D11. I saw someone earlier in the chat box say the court's going to be inundated with D11s. I think they really are. But you need to put in a D11 supported by evidence, declare the grounds upon which a costs order is sought, and then a summary showing how the costs sought have been calculated. You don't need to put in an N260. The President said yesterday, but I don't know why you wouldn't use one specifically. A respondent who disputes the costs order or the amount claimed must file a witness statement. And then in standard cases, the court is saying we will deal with costs applications without a hearing. That is different for costs in disputed cases. where the court is saying it's likely going to need, so I'll just wait for the slide to move. Yeah, so the court is saying likely going to need a separate hearing to determine costs where there's been a dispute over jurisdiction, and I mean that in terms of jurisdiction, in terms of location, but also whether the marriage is in subsistence or whether it's already been ended. And then it will normally, is what the guidance says, be appropriate to order that the unsuccessful party pay the successful party's costs. So if you are successfully disputing on the basis of jurisdiction or on the basis that there's already been a divorce in another country, then you can still apply for your costs in, I'm going to say, the usual way, in terms of when there has been a factual dispute in these sorts of cases, then you can still apply for costs. But in disputed cases, we're being told the guidance is that a separate hearing will be required. I don't know whether any of you will have read this, but I've included it in case some of you haven't. But this Nuffield Foundation report on costs in divorce and dissolution, that was a report prepared by Professor Liz Trinder at the University of Exeter. It was a really interesting read, and it did deal briefly with the issue of costs in no-fault divorce cases. Obviously, it was produced long before the issue was going to become relevant and imminent as it has now. But the loose recommendations from her is that the no-fault system really should only encourage costs when there's been litigation misconduct. So, for example, if you have had issues with somebody evading service, then you would be able to apply for your costs and perhaps be successful in that regard. But costs orders in and of themselves do appear to us, at least, to be completely contradictory to the whole point of no-fault divorce, where we are supposed to be seeing this sea change in society about how we look at marriage breakdown. So perhaps something to think about. But again, I fully anticipate that this is just going to be a new battleground. Just a couple of ancillary points. The archaic criteria for applying for decree absolute, what used to be called decree absolute out of time, are gone. I'm sure we have all been there at the end of an FDR or a final hearing, and you turn to your client and you say, when did you apply for decree nisi? When was that granted? And they say, oh, it was 2 years ago or something. And you then are filled with horror having to explain to them as to why you're asking whether they have had any children whose father is or could be their ex-husband. That is all gone. What there now is on the notice for making a conditional order final, the first box on the application form is, has it been over 12 months since you had your conditional order? If so, why has it taken you 12 months or over 12 months to apply for a final order? And that's it. You just provide your explanation. I'm assuming 9 times out of 10, it's going to be that it's because of the finances being sorted. The court may require an explanation for this to be verified by a statement of truth. It doesn't say it has to be, but it's in the notice, which is obviously going to be signed when it's put in. So that will be there. And I've put a screenshot of that on the next slide so everyone can see what I'm talking about. Yeah, here we go. So are you giving notice of this application more than 12 months after the conditional order was made? Yes, this is because, and then there's a box for you to fill all of that out. Helpfully also, hopefully that screenshot deals with the point that was raised earlier about joint applicants not being able to apply for a final order together. Hopefully you could see on that screenshot that that's not the case. A note on remarriage and financial remedies. So the new D8 form has got the box on it that you can tick to say that you want to apply for a financial order, which means that you don't get stuck in the remarriage trap. So that also, I've taken a screenshot of it. That's on the next slide. So we can all see, yeah, do you want to apply for a financial order? And then you've got sole applicant or applicant 1 and then applicant 2. And you can say there so that if your client is particularly keen to go off and get remarried ASAP, they can go and do that, and they've still got the ability to apply financial remedies after they have remarried, but they've got to tick that box. And that is it.
So thank you very much, everyone, for joining us. We're going to have a quick look in the couple of minutes that we've got left at some questions. Now, as we've been going along, I think we have managed to answer a number of them. And I see that particularly something that has vexed a lot of people, as it's vexed us, is this idea of a solicitor acting for both parties. And I think what Samara and I concluded is, yes, it's possible for the solicitor to act for both parties, but if there is any possibility of there being any future dispute, whether it's the children, whether it's the finances, it's probably not wise to represent both parties, because you're then conflicted out of any later representation. So I think that the better route is to suggest that actually here are the forms, go away with your ex and do it together, because frankly, if they're doing the joint application, there's got to be a measure of agreement between them anyway. Moving on to costs, because there are a number of questions about that, and then I'll let Samara answer some as well. But moving on to costs, I think the big thing is that we are moving on into an era of this idea that the divorce is meant to be by agreement as far as possible. And so the view was that in a standard case, given the costs, and I think the new fee is going to be 593, I think it's still that, that given those costs are limited, it is not worth arguing about who pays it. With the joint application, of course, you can have that decision between them. I suspect the other reason they haven't gone into the realms of saying, why don't we share costs, is because they can't administratively deal with both parties paying it separately. So it's sort of leaving you to come to a private arrangement. And I think that is why that is the case. Someone's asked about getting help with fees. The My Help with Fees still applies. Samara, I don't know if you picked up any additional questions while I've been looking through. Someone's asked, did I miss a change in the FPR? I don't know if
that was to do with, I think, me referring to it as permission.
Fine.
To apply for DA out of time. Yes, I agree. That's a colloquialism that judges have just picked up on, and I somewhat lazily have picked up on as well.
You are going to get, would have been nice to get a look at the new forms. William, you can get the new forms. They're all on the, as I've said, they're all available on Resolution. I don't think it would have been worth our time printing them out and screenshotting them all here, because they are available on the Resolution website. So I hope that helps. And you'll see they've included Daffy Duck and his wife as the parties. Is it still good? Yeah, sorry, go on.
No, I was just going to say, someone has just said that no doubt, another problem no doubt will be in situations where one party is applying for the final order, however the other party wishes to delay the final order. That's where we consider people will be making more applications under section 10.2, because that has changed to be for all cases, not just separation cases, because of course we don't have those grounds anymore, as Tara was explaining. So yes, we think that people will be doing that if you've got a difficult litigant who's trying to delay the divorce. We absolutely think that that's going to become a new argumentative battleground. Somewhat annoyingly, we couldn't see, I mean, it's not on either of the forms, either to apply for a conditional order or to make the notice to make the conditional order final. There isn't a box that says, are you engaged in financial remedies proceedings currently, no, and or are you discussing this by way of voluntary disclosure or something? No. There is nothing that deals with whether you are sorting out your finances. So we anticipate that if somebody is trying to make a conditional order final and you're saying, hold on a minute, we haven't sorted out the finances, there's going to be triggered an application under section 10.2 by way of our favourite friend, a D11.
It does, and someone's just asked that. It does have to be by a D11 for a section 10.2 application. And then people have asked, does the form include anywhere that you could put fault? And the answer to that is no. It is merely the statement that there has been a breakdown. I know people on there have said, well, it would help our clients if they could assign fault, but I mean, that's the whole point of this no fault divorce, isn't it? That is just to be gone away with, because it's not going to be relevant, particularly in the finances. lots of questions still coming through, and many people thanking us. So that's lovely to see. Thank you for that.
Yes, D11 will be a separate
Yes.
fee incurred. Yeah, I think there are going to be fees all over the shop here.
Yeah.
We agree. It's not great. Do we not file a Form B? We couldn't see any guidance that said that. We assumed it was a D11. The information pack makes it fairly clear a separate application is needed.
Yeah, that's right. Well, I think we will probably end it there. As I say, if anyone does have some questions, we are more than happy to take them by email. It's been a bit difficult racing through all the different comments and actually trying to elucidate them. So we're really sorry if we haven't answered your question. Many thanks for joining us. I think we've had a new record today with over 680 people joining. So that was wonderful. And we really hope that we've been a help. And good luck, everyone, from the 6th of April. Many thanks.